State may proceed.
Your Honor, as the reason for downward departure should be shown by defense, I believe Ms. Gooden should proceed first.
I'm sorry?
As reasons for downward departure need to be shown by a preponderance of the evidence by Ms. Gooden, I believe she should proceed first.
Ms. Gooden?
Yes, Your Honor. The only witness I have is my client, Eldon Garlough.
Okay. Very good. If you'd come up to the witness stand.
I think he wants you to up there. Witness stand or at the podium, Your Honor?
Witness stand. Please raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Please be seated, and you can speak into the mic. Ms. Gooden, you may inquire.
Would you state your full name for the record?
Eldon David Garlough,
And Mr. Garlough, how old are you?
63 years old.
And would you tell the court about your medical conditions, specifically about your heart and your liver?
Yes, I have heart disease. I have a dual chamber pacemaker that was put in 2020. I have a cardiologist that I must see 2 or 3 times a year so he can monitor my pacemaker and monitor my medications that I take for my heart. I also have cirrhosis of the liver. The doctors, frankly, don't know how long I have to live because of that. There's no medication for cirrhosis of the liver. The only thing you can do is live a healthy life and have a healthy diet. Yes, ma'am.
As far as your heart goes, the pacemaker, are there any concerns with malfunctions or anything like that?
There is. That's why before I was incarcerated, I had to carry around a card with me to show who my cardiologist was in case something happened, and they would know, the medics would know who to call and address whatever's happening with the pacemaker at the time.
And how often would you see your cardiologist?
I would see him about 4 times a year unless my heart was not feeling well. So, and the past year, I've seen him more than that, because they'd have to bring in a specialist who is a specialist with pacemakers, and they would have to do a check on my pacemaker to make sure it's functioning correctly.
And with your heart condition, how many different medications do you take because of it?
I'm taking a blood thinner. I'm taking 1, 2, 3, about 5 or 6 different medications.
And do you remember the names of those medications?
Eliquis is one. Lopressor is another one. The technical names of the other ones I don't remember. Eliquis is very important. The doctors here tried to take me off it in the county jail here. So I had to work hard to get them to make sure that I stayed on it. So it took them about 10 days to get it ordered, and so I could stay on the Eliquis. It's a blood thinner for me.
And you said for cirrhosis of the liver, there is no medication that you can take?
There is no medication except a healthy diet, and they just don't know how long I have to live.
And how severe is the cirrhosis?
It's very, very bad.
What symptoms are manifested because of the heart and also because of the liver?
I just don't have a quality of life. I'm not feeling well at all. I don't ever feel well. I'm lethargic all the time. I don't have any energy. My chest hurts at times, and that's when I have to go and see my cardiologist. Same way with my liver. My quality of life is terrible.
Are any of these physical issues due to substance abuse?
No, ma'am, none whatsoever.
And are you able to get all of the medications that you were on in the county jail? You said you got them to get one of them.
The county jail will not even issue you aspirin. I have a degenerated disc in my back. I've been sleeping on the floor in the county jail for the last 2 months because it's overcrowded. So they call these boats that you sleep on. It's a big piece of plastic with a thin mat. But the doctor will not even, he will not prescribe aspirin or anything else for my back. Of my medications, when I was incarcerated, I had a cardiologist, I had a gastrologist specialist for my liver, and I had a specialist for my skin. I also have eczema on my skin, which I scratch all the time. All of these things, which I had many meds for, the doctors here just threw them out. They said, you don't need them, and we're not going to prescribe them. They did prescribe the ones for my heart. So I'm taking the ones for the heart right now.
Those are all the questions I have regarding the downward departure.
I don't have any questions for the defendant.
Mr. Garlough, you may step down, sir. Any further witnesses?
No, Your Honor. My client is going to testify and address the court regarding his personal, but I believe that goes after the state, unless you want us to go ahead and do it all now.
I believe defense should put their case for downward departure on the record, and then the state will proceed.
Well,
When you respond to my arguments, if need be.
If it's not based on a downward departure, then,
then we'll go after the state.
so it's not based on, so you're limiting the testimony of just the recent, this past testimony as to the reasons for a downward departure.
Yes, Your Honor.
Okay. State may proceed.
Thank you, Judge. Did you have the benefit of my sentencing packet as well as the
Ma'am,
score sheet?
and I've read it.
Okay. Did you also, were you also able to read the amended PSI filed January 9th?
I did.
All right. As the court is well aware, Mr. Garlough was found guilty by a jury of his peers on 10 counts of possession of certain images of child pornography. He is facing a maximum of 150 years, and he scores 198 points, which translates into presumptively facing 127.5 months in the Department of Corrections. As we outlined in our letter, we're asking the court to adjudicate him guilty and sentence him to 20 years in the Department of Corrections, followed by 10 years of sex offender probation. The court heard the case for itself back in November, so we won't get much into the facts today. But you'll recall that it began with Investigator Evans using a program to identify those possessing child pornography using a peer-to-peer software. Law enforcement was able to identify that IP address, and Cox Communications determined it belonged to Eldon Garlough. The search warrant was then executed on his address in March of 2021, and law enforcement testified that during the device triage, child pornography was located on a computer in a room surrounded by Dallas Cowboys sports memorabilia. Mr. Casey Campbell also found additional child pornography on another device. The child pornography that the defendant had in his possession featured children as young as 5, and the 10 counts that he's been found guilty of qualified for enhancement due to the very young age of the children, the fact that some were videos, and some featured sexual battery of those children. And while the court had the benefit of viewing select clips of those charged counts, some were much longer. Count 4, for instance, was over an hour long. In addition, the search terms and drive downloads indicate the defendant was clearly seeking out these child sexual abuse materials. In order to downward depart, it's a two-part basis. First, whether the court can depart, that is, whether defense has shown a legally sufficient basis for a departure, and secondly, the court's discretion as to whether it should depart. Defense today is arguing for a downward departure based on specialized treatment for a mental or physical disorder unrelated to substance abuse, and that the defendant is amenable to that treatment. In order for defense to use that downward departure basis, they must show, and the court must find, 3 things. First, the existence of a mental disorder or physical disability. Second, the need for specialized treatment. And third, that the defendant is amenable to treatment. We would take issue with the first prong of that analysis, the existence of a physical disability or mental disorder. That must be shown by competent, substantial evidence. The only current evidence before the court that it exists is the self-report of the defendant in his PSI and testimony today. Defense would also need to show a need for specialized treatment. That's the second prong of the test. The issues that were reported today include things such as heart disease and cirrhosis of the liver, blood pressure issues, and I believe a herniated disc. Those are not issues that require specialized treatment. Lastly, defense must show that the defendant is amenable to treatment, and we don't believe there's been any testimony regarding that today. So we don't believe defense has met their burden to qualify for downward departure. However, even if the court believes defense has met their burden to show there is a reason for downward departure, we do not believe it's appropriate in this case. The nature of the defendant's crimes, the severity of the images and videos, and the danger that he poses to children and the community lead the state to ask you to impose a 20-year Department of Corrections sentence, followed by 10 years on sex offender probation. The defendant and his PSI reference being sexually abused. However, that does not excuse seeking out child sexual abuse-related materials. If anything, the defendant should know better than most the consequences and the effect that has on others. Seeking out and possessing child sexual abuse materials creates a further market for the materials and leads to more children being abused, and it feeds that market. And the victims in those images and videos that he had in his possession were re-victimized every time that image or video is viewed or shared or downloaded. And while there are no named victims in this case, there are certainly victims. The purpose of criminal courts is not to rehabilitate the defendant, it's to protect the public and hold the defendant accountable for his actions. So again, we are asking the court to sentence the defendant to 20 years in the Department of Corrections, followed by 10 years of sex offender probation, and the conditions outlined in our letters to the court. Thank you.
That's good.
Thank you, Your Honor. Your Honor, I do believe that the defense has met the burden required for a downward departure. The state said that we did not show that the client was amenable to treatment. However, my client testified that he has been seeing his doctors and taking his medication, but for being incarcerated, he was seeing them on a regular basis and as needed. And when issues arose. So he is amenable to treatment for his heart condition, his high blood pressure, his liver disease, the eczema, and the degenerative disc issues. So we believe we have met the burden for the court to consider a downward departure based on his medical needs. What you have before you is a 63-year-old man who spent 43 years of his life serving the country. He did so as a active military and then afterwards as a civil servant at Eldon Air Force Base. He was in charge of over 750 people for one of the largest squadrons in Eldon. He basically gave his life to the country and had top security clearance. He's never been in trouble. He's never been arrested. He's fought all over the world. We ask the court to consider a downward departure. If the court is not willing to do the downward departure, then we ask the court to consider giving him the low end of the guidelines of 127.5. And if the court, you want to address the court? My client would like to address the court.
Sir, as my lawyer has pointed out, I do have severe medical problems. I also have a wife who is 77 years old. We've been married for 41 years. She has dementia. She can't take care of herself. This is very hard for me and for her especially. As she said, I spent my whole life in the Air Force. I was sexually abused as a child from the ages of 18 to 14. One of the reasons I left my home in New York was to get away from what happened to me. So at 18 years old, I joined the Air Force. I tried to put everything behind me. I have suffered from depression through my whole life. I have had counseling because of what happened to me when I was younger. I was able to overcome some of it, but then it started to come back to me. I spent my whole life serving my country, serving the freedoms that people have, serving the what the court means, what life means. This is what I fought for. I fought all over the world in many conflicts and many wars, only to make sure that everybody had a fair chance at life. After I retired from the Air Force in 2004, I immediately joined back in the Air Force as a civil service individual because I love my country. There's nothing more than there's nothing more than I love my country. I had a clean record. I've never been arrested for anything. I have held a top secret clearance, which I've been investigated many times. And I've commanded people, mentored people throughout my whole life. I just ask that have pity on me. And you take into account everything I've done for my country and for my medical health that is declining right now.
Do you have anything else? We have nothing further, Your Honor.
Thank you very much. Okay. Court will take a very brief recess. I'll come back in just a second.
All right.
Your Honor, if I may? One thing I forgot to ask is that if you sentence him to the 10 counts, which you are going to sentence him to the 10 counts, that you consider to sentence them concurrent, not consecutive.
The state wished, I'm not exactly sure that,
Your Honor, for each of the 10, they're second-degree felonies, so there's only 15 years jurisdiction on each. So however
there's only what?
For each count, they're a F2, L6, so for each count, there's only 15 years jurisdiction. So however you wanted to break down the counts, depending on your sentence, is acceptable to the state. But you can do them consecutively. I do have another copy of the score sheet if it would assist, Your Honor.
Counsel approach. So first, as it relates to the issue of the downward departure, the court finds that the defense has not proved the three elements necessary for a downward departure. And the court would further say that even if the defense did prove it, the court's not departing downward. So the court would exercise its discretion not to depart, have a downward departure, even if the issue or the category of a downward departure would have been proved. So, based upon that, the court is going to sentence the defendant to 127.5 months in the Department of Corrections for each of the 10 counts. The 10 counts will be served concurrent at that level. This sentence will be followed by 10 years of sex offender probation. That was the question that I had. If it's past the 15 years, how would that be properly structured?
You could perhaps make count 9, 10 years of sex offender probation consecutive to counts 1 through 9.
Okay,
Or
Or
count
10, I'm
10.
sorry. Count 10.
okay, very good. That's what the court intends to do. I want to make sure that there's the 10 years of sex offender probation. The court, pursuant to Florida Statute 943.0435, subsection 1, will designate the defendant as a sexual offender in order that he complete all the statutory requirements, including a complete sex offender counseling and treatment. The defendant would be placed on a GPS monitor for any time that he's on sex offender probation under the Jessica Lunsford Act, provide DNA sample, have no contact with minors, no internet access or use of devices capable of internet access, forfeiture any seized devices, and all applicable court costs, including the $100 cost of prosecution, and pay the cost of supervision while on sex offender probation. Does the state need anything further?
No, Your Honor, we'll submit a sex offender order to the court.
Ms. Gooden, anything further?
And the court cost will be,
Very good.
151, just once or 10 times?
One court cost for the entire.
And, Your Honor, I would ask that amount be given 90 days after he's released to set up a payment plan so that it's not reduced to a judgment.
There's no objection.
Okay. Very good, 90 days.
And I've advised my client he has 30 days to appeal the judgment and sentence.
Thank you for pointing that out. That is an important factor. Defense always has 30 days to file an appeal.
Thank you, Your
Okay,
Honor.
anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Thank you very much.
You understand? He gave you the least amount that he
Sort of.
gave you.
My dad argued this in court, yeah.
And